Lesson 5. Issue and redemption of debentures and bonds. Learning objectives. The issue and redemption of debentures are regulated by Section 71 of Companies Act, 2013. Read with Rule 18 of Companies, Share Capital and Debentures, Rules, 2014. In addition, in case of issue and listing of non-convertible debt instruments, the provisions of SEBI, Issue and Listing, of Debt Securities Regulations 2008, and in case of convertible debt instruments SEBI, ICDR, Regulations, 2009 are to be complied with. After reading this lesson, you will be able to understand the procedural aspects of debt securities, including convertible and non-convertible instruments. Debentures. A debenture is an instrument of debt executed by the company acknowledging its obligation to repay the sum at a specified rate and also carrying an interest. It is one of the methods of raising the loan capital of the company. A debenture is thus like a certificate of loan or a loan bond, evidencing the fact that the company is liable to pay a specified amount with interest, and although the money raised by the debentures becomes a part of the company's capital structure, it does not become share capital. As per Section 230 of the Companies Act 2013, debenture includes debenture stock, bonds, or any other instrument of a company evidencing a debt, whether constituting a charge on the assets of the company or not. The debentures in a company shall be movable property, transferable in the manner provided by the Articles of the Company according to Section 44. Types of debentures. On the basis of charge, the Section 230 of the Companies Act 2013 clarifies that the debentures can be secured or unsecured. A. Secured debentures, where debentures are secured by a mortgage or a charge on the property of the company, they are called secured debentures. Debentures that are secured by a mortgage of the whole or part of the assets of the company are called mortgage debentures or secured debentures. The mortgage may be one duly registered in the formal way or one which is secured by the deposit of title deeds in case of urgency. If the issuer defaults in the repayment of principal or payment of interest, his assets can be sold to repay the liability to the investors. B. Unsecured debentures, where they are not secured by any mortgage or charge on any property of the company, they are said to be naked or unsecured debentures. These debentures did not carry any charge on the assets of the company. The holders of such debentures did not therefore have the right to attach particular property by way of security as to repayment of principal or interest. If the issuer defaults in the repayment of principal or payment of interest, the investor has to be along with the unsecured creditors of the company. On the basis of convertibility, the Section 71(1) of the Companies Act 2013, a company may issue debentures with an option to convert such debentures into shares, either wholly or partly at the time of redemption. Thus, on the basis of convertibility, debentures can be convertible and non-convertible debentures. Convertible debentures can be fully convertible or partly convertible. A. Convertible debentures, where the debentures are convertible, partly or wholly, into the shares of a company after a specified time, either as a result of exercise of option or in terms of the issue, they are called convertible debentures. Convertible debentures can be of following two types. I. Fully convertible debentures, FCDs. These are convertible into equity shares of the company with or without premium as per the terms of the issue, on the expiry of specified period or periods. The tenure of the convertible securities of the issuer shall not exceed 18 months from the date of their allotment. Interest will be payable on these debentures up to the date of conversion as per terms of the issue. 2. Partly convertible debentures, PCDs. These may consist of two kinds, namely, convertible and non-convertible. The convertible portion is to be converted into equity shares at the expiry of specified period. However, the non-convertible portion is redeemed at the expiry of the stipulated period. If the conversion takes place at or after 18 months, the conversion is optional at the discretion of the debenture holder. Bonds. Bonds are typically issued by financial institutions, government undertakings, and large companies. The interest rate is assured and is paid at a fixed interval. On maturity, the principal is repaid. Bond is a form of loan. The holder of the bond is the lender and the issuer of the bond is the borrower. Bonds are issued to fund long-term capital expenditure needs. As per Section 230 of the Companies Act 2013, debenture includes bonds. Therefore, all the provisions applicable for debentures given in the Companies Act 2013 and other relevant statutes are applicable for bonds also. Types of bonds. Some of the types of bonds issued in the Indian markets are given below. Deep discount bonds, also known as zero coupon bonds, are bonds wherein there is no interest or coupon payment and the interest amount is factored in the maturity value. Corporate bonds are issued by companies and offer interest rates higher than bonds issued by public sector units and other financial institutions. The interest rate on these bonds is governed by their credit rating, and higher the rating, lower is the interest rate offered by them. Sovereign bonds are issued by the Reserve Bank of India. These can be referred to as low-risk or even risk-free bonds. Convertible bonds are another category wherein the bondholders has an option to convert the bonds into equity after a fixed tenor. These may be fully or partially convertible, where only a part is converted and the other part matures. Issue of debentures. Section 71(1) of the Companies Act 2013 specifies that any company may issue debentures with an option to convert such debentures into shares, either wholly or partly at the time of redemption. The debentures can be issued in the same manner as shares in a company. But unlike shares, debentures can be issued at a discount or at a premium. The Companies Act 2013 places no restriction in this regard. Debentures can be issued by any type of company: one-person company, small company, private company, public company, or listed company. Debentures cannot have voting rights. A public company has to appoint debenture trustee before the issue of debentures. Any company can issue secured or unsecured debentures. For secured debentures, conditions for issue of secured debentures under the Companies Act 2013 have to be followed. Debenture trustee has to be appointed and the trust deed in Form No. Sh 12 has to be executed. Any company can issue debentures which are convertible or non-convertible. For convertible debentures, a special resolution should be passed at a general meeting. A company shall pay interest and redeem the debentures in accordance with the terms and conditions of their issue. Interest payable on them is a debt and can be paid out of capital. There is no ceiling, minimum or maximum, for the rate of interest payable on debentures. Where debentures are issued by a company, the company shall create a debenture redemption reserve account out of the profits of the company available for payment of dividend, and the amount credited to such account shall not be utilized by the company except for the redemption of debentures. Where a company fails to redeem the debentures on the date of their maturity or fails to pay interest on the debentures when it is due, the tribunal may, on the application of any or all of the debenture holders, or debenture trustee, and, after hearing the parties concerned, direct, by order, the company to redeem the debentures forthwith on payment of principal and interest due thereon. Notified WEF 1st June, 2016. If any default is made in complying with the order of the tribunal under this section, every officer of the company who is in default shall be punishable with imprisonment for a term which may extend to 3 years, or with fine which shall not be less than 2 lakh rupees but which may extend to 5 lakh rupees, or with both. Notified WEF 1st June, 2016. A contract with the company to take up and pay for any debentures of the company may be enforced by a decree for specific performance. For issue and listing of non-convertible debt securities, Securities and Exchange Board of India, issue and listing of debt securities, regulations, 2008 has to be followed. For issue and listing of convertible debt securities, provisions mentioned in Securities and Exchange Board of India, issue of capital and disclosure requirements, regulations, 2009 has to be followed. Section 71(2) states that no company shall issue any debentures carrying any voting rights. Conditions for issue of secured debentures. Section 71(3) states that a company may issue secured debentures subject to terms and conditions as prescribed. According to Rule 18(1) of the Companies, Share Capital and Debentures, Rules, 2014, the company shall not issue secured debentures, unless it complies with the following conditions, namely, a. An issue of secured debentures may be made, provided the date of its redemption shall not exceed 10 years from the date of issue, provided that the following classes of companies may issue secured debentures for a period exceeding 10 years but not exceeding 30 years, I. companies engaged in setting up of infrastructure projects. 2. Infrastructure finance companies as defined in Clause VEA of Subdirection 1 of Direction 2 of Non-Banking Financial, Non-Deposit Accepting or Holding Companies Prudential Norms, Reserve Bank, Directions, 2007. 3. Infrastructure Debt Fund Non-Banking Financial Companies as defined in Clause B of Direction 3 of Infrastructure Debt Fund Non-Banking Financial Companies, Reserve Bank, Directions, 2011. 4. Companies permitted by a ministry or department of the central government or by Reserve Bank of India or by the National Housing Bank or by any other statutory authority to issue debentures for a period exceeding 10 years. B. Such an issue of debentures shall be secured by the creation of a charge, on the properties or assets of the company, having a value which is sufficient for the due repayment of the amount of debentures and interest thereon. C. The company shall appoint a debenture trustee before the issue of prospectus or letter of offer for subscription of its debentures and not later than 60 days after the allotment of the debentures, execute a debenture trust deed to protect the interest of the debenture holders, and D. The security for the debentures by way of a charge or mortgage shall be created in favor of the debenture trustee on I. Any specific movable property of the company, or 2. Any specific immovable property wherever situate, or any interest therein, provided that in case of a non-banking financial company, the charge or mortgage under subclause I may be created on any movable property, provided further that in case of any issue of debentures by a government company which is fully secured by the guarantee given by the central government or one or more state government or by both, the requirement for creation of charge under this subrule shall not apply, provided also that in case of any loan taken by a subsidiary company from any bank or financial institution the charge or mortgage under this subrule may also be created on the properties or assets of the holding company. Debenture Redemption Reserve Section 71(4) states that where debentures are issued by any company under this section, the company shall create a debenture redemption reserve account out of the profits of the company available for payment of dividend, and the amount credited to such account shall not be utilized by the company except for the redemption of debentures. Rule 18(7) states that the company shall create a debenture redemption reserve for the purpose of redemption of debentures. In accordance with the conditions given below, A. The debenture redemption reserve shall be created out of the profits of the company available for payment of dividend. B. The company shall create debenture redemption reserve, DRR, in accordance with following conditions. I. No DRR is required for debentures issued by All India Financial Institutions, AFIs, regulated by Reserve Bank of India, and banking companies for both public as well as privately placed debentures. For other financial institutions, FIs, within the meaning of Clause 72 of Section 2 of the Companies Act, 2013, DRR will be as applicable to NBFCs registered with RBI. 2. For NBFCs registered with the RBI under Section 45(a) of the RBI Amendment Act, 1997, the adequacy of DRR will be 25% of the value of debentures issued through public issue as per present SEBI, Issue and Listing of Debt Securities, Regulations, 2008. And no DRR is required in the case of privately placed debentures. 3. For other companies including manufacturing and infrastructure companies, the adequacy of DRR will be 25% of the value of debentures issued through public issue as per present SEBI, Issue and Listing of Debt Securities, Regulations 2008, and also 25% DRR is required in the case of privately placed debentures by listed companies. For unlisted companies issuing debentures on private placement basis, the DRR will be 25% of the value of debentures. C. Every company required to create debenture redemption reserve shall on or before the 30th day of April in each year, invest or deposit, as the case may be, a sum which shall not be less than 15%, of the amount of its debentures maturing during the year ending on the 31st day of March of the next year, in any one or more of the following methods, namely, I. In deposits with any scheduled bank, free from any charge or lien. 2. In unencumbered securities of the central government or of any state government. 3. In unencumbered securities mentioned in subclauses A, 2, D, and E, of Section 20 of the Indian Trusts Act, 1882, 4, in unencumbered bonds issued by any other company which is notified under subclause F, of Section 20 of the Indian Trusts Act, 1882, v. The amount invested or deposited as above shall not be used for any purpose other than for redemption of debentures maturing during the year referred above, provided that the amount remaining invested or deposited, as the case may be, shall not at any time fall below 15% of the amount of the debentures maturing during the year ending on the 31st day of March of that year. D. In case of partly convertible debentures, debenture redemption reserve shall be created in respect of non-convertible portion of debenture issue in accordance with this sub-rule. E. The amount credited to the debenture redemption reserve shall not be utilized by the company except for the purpose of redemption of debentures. Debenture trustee. A debenture trustee means a trustee of a trust deed for securing any issue of debentures of a body corporate. Section 71(5) specifies that no company shall issue a prospectus or make an offer or invitation to the public or to its members exceeding 500 for the subscription of its debentures, unless the company has, before such issue or offer, appointed one or more debenture trustees. The conditions governing the appointment of debenture trustees under subsection 5 of Section 71 are prescribed under Rule 18(2) of the Companies, Share Capital and Debentures, Rules, 2014. A. The names of the debenture trustees shall be stated in letter of offer inviting subscription for debentures and also in all the subsequent notices or other communications sent to the debenture holders. B. Before the appointment of debenture trustee or trustees, a written consent shall be obtained from such debenture trustee or trustees proposed to be appointed and a statement to that effect shall appear in the letter of offer issued for inviting the subscription of the debentures. C. A person shall not be appointed as a debenture trustee, if he I beneficially holds shares in the company. 2. Is a promoter, director or key managerial personnel or any other officer or an employee of the company or its holding, subsidiary or associate company. 3. Is beneficially entitled to monies which are to be paid by the company otherwise than as remuneration payable to the debenture trustee. 4. Is indebted to the company, or its subsidiary or its holding or associate company or a subsidiary of such holding company. V. Has furnished any guarantee in respect of the principal debt secured by the debentures or interest thereon. 5. Has any pecuniary relationship with the company amounting to 2% or more of its gross turnover or total income or 50 lakh rupees or such higher amount as may be prescribed, whichever is lower, during the 2 immediately preceding financial years or during the current financial year. 7. Is relative of any promoter or any person who is in the employment of the company as a director or key managerial personnel. D. The board may fill any casual vacancy in the office of the trustee, but while any such vacancy continues, the remaining trustee or trustees, if any, may act, provided that where such vacancy is caused by the resignation of the debenture trustee, the vacancy shall only be filled with the written consent of the majority of the debenture holders. E. Any debenture trustee may be removed from office before the expiry of his term only if it is approved by the holders of not less than 3/4 in value of the debentures outstanding, at their meeting. To act as debenture trustee, the entity should either be a scheduled bank carrying on commercial activity, a public financial institution, an insurance company, or a body corporate. The entity should be registered with SEBI to act as a debenture trustee. In India, the issuer pays to the debenture trustee. Debenture trustees are regulated by SEBI. The SEBI, Debenture Trustees, Regulations, 1993 govern the debenture trustees and provide for eligibility criteria for registration of debenture trustees, monitoring and review, registration, code of conduct, procedure of action in case of defaults, avoidance of conflict of interest and inspection of debenture trustees by SEBI, amongst other things. 9. Nothing contained in the rule shall apply to any amount received by a company against issue of commercial paper or any other similar instrument issued in accordance with the guidelines or regulations or notification issued by the Reserve Bank of India. 10. In case of any offer of foreign currency convertible bonds or foreign currency bonds issued in accordance with the foreign currency convertible bonds and ordinary shares, through depository receipt mechanism, scheme, 1993 or regulations or directions issued by the Reserve Bank of India, the provisions of this rule shall not apply unless otherwise provided in such scheme or regulations or directions. Duties of Debenture Trustee Section 71(6) of the Companies Act, 2013 says that a debenture trustee shall take steps to protect the interests of the debenture holders and redress their grievances. Rule 18(3) states that it shall be the duty of every debenture trustee to a. Satisfy himself that the letter of offer does not contain any matter which is inconsistent with the terms of the issue of debentures or with the trust deed, b. Satisfy himself that the covenants in the trust deed are not prejudicial to the interest of the debenture holders, c. Call for periodical status or performance reports from the company, d. Communicate promptly to the debenture holders defaults, if any, with regard to payment of interest or redemption of debentures and action taken by the trustee, e. Appoint a nominee director on the board of the company in the event of I. 2 consecutive defaults in payment of interest to the debenture holders, or 2. Default in creation of security for debentures, or 3. Default and redemption of debentures. F. Ensure that the company does not commit any breach of the terms of issue of debentures or covenants of the trust deed and take such reasonable steps as may be necessary to remedy any such breach. G. Inform the debenture holders immediately of any breach of the terms of issue of debentures or covenants of the trust deed. H. Ensure the implementation of the conditions regarding creation of security for the debentures, if any, and debenture redemption reserve. I. Ensure that the assets of the company issuing debentures and of the guarantors, if any, are sufficient to discharge the interest and principal amount at all times and that such assets are free from any other encumbrances except those which are specifically agreed to by the debenture holders. J. Do such acts as are necessary in the event the security becomes enforceable. K. Call for reports on the utilization of funds raised by the issue of debentures. L. Take steps to convene a meeting of the holders of debentures as and when such meeting is required to be held. M. Ensure that the debentures have been converted or redeemed in accordance with the terms of the issue of debentures. N. Perform such acts as are necessary for the protection of the interest of the debenture holders and do all other acts as are necessary in order to resolve the grievances of the debenture holders. Where at any time the debenture trustee comes to a conclusion that the assets of the company are insufficient or are likely to become insufficient to discharge the principal amount as and when it becomes due, the debenture trustee may file a petition before the tribunal and the tribunal may, after hearing the company and any other person interested in the matter, by order, impose such restrictions on the incurring of any further liabilities by the company as the tribunal may consider necessary in the interests of the debenture holders. Notified WEF 1 June, 2016, some of the obligations of debenture trustees provided in the SEBI, Issue and Listing of Debt Securities, Regulations, 2008 RI. The debenture trustee shall be vested with the requisite powers for protecting the interest of holders of debt securities, including a right to appoint a nominee director on the board of the issuer in consultation with institutional holders of such securities. 2. The debenture trustee shall carry out its duties and perform its functions under these regulations. The Securities and Exchange Board of India, Debenture Trustees, Regulations, 1993, the trust deed and offer document, with due care, diligence and loyalty. 3. The debenture trustee shall ensure disclosure of all material events on an ongoing basis. 4. The debenture trustees shall supervise the implementation of the conditions regarding creation of security for the debt securities and debenture redemption reserve. Role of debenture trustee with respect to creation or enforcing the security in a debenture issue. Creation of security means mortgaging the property in favor of debenture trustee for the benefit of debenture holders. This is an incidence of ownership of property, and creation of security has to be done by the owner of the property. However, the debenture holders are beneficiaries and they have no access to mortgaged property. The debenture trustee holds the secured property on behalf of issuer of security and for benefit of debenture holders. In the event of default by the issuer of security, the debenture trustee will have the power and authority to bring the secured property to sale following the procedure in the Transfer of Property Act, and the proceeds of sale will have to be applied to redeem the debentures. Debenture trust deed. Debenture trust deed is a written instrument legally conveying property to a trustee, often for the purpose of securing a loan or mortgage. It is the document creating and setting out the terms of a trust. It will usually contain the names of the trustees, the identity of the beneficiaries, and the nature of the trust property, as well as the powers and duties of the trustees. It constitutes trustees charged with the duty of looking after the rights and interests of the debenture holders. As per Section 71(7), any provision contained in a trust deed for securing the issue of debentures, or in any contract with the debenture holders secured by a trust deed, shall be void insofar as it would have the effect of exempting a trustee thereof from, or indemnifying him against, any liability for breach of trust, where he fails to show the degree of care and due diligence required of him as a trustee, having regard to the provisions of the trust deed conferring on him any power, authority or discretion, provided that the liability of the debenture trustee shall be subject to such exemptions as may be agreed upon by a majority of debenture holders holding not less than 3/4 in value of the total debentures at a meeting held for the purpose. A trust deed for securing any issue of debentures shall be open for inspection to any member or debenture holder of the company, in the same manner, to the same extent and on the payment of the same fees, as if it were the register of members of the company, and a copy of the trust deed shall be forwarded to any member or debenture holder of the company, at his request, within 7 days of the making thereof, on payment of fee. As per Section 71 and Sub-Rule 1, of Rule 18 of the Companies, Share Capital and Debentures, Rules, 2014, a trust deed in Form No. sh.12 or as near thereto as possible shall be executed by the company issuing debentures in favor of the debenture trustees within 3 months of closure of the issue or offer. Rule 18.5, as given in Form No. sh.12, the debenture trust deed shall, inter alia, contain the following: 1. Description of debenture issue, a. Purpose of raising finance through the debenture issue, b. Details of debenture issue as regards amount, tenure, interest, coupon rate, periodicity of payment, mode of payment and period of redemption. C. An undertaking by the company to pay the interest and principal amount of such debentures to the debenture holders as and when it becomes due, as per the terms of offer. D. The terms of conversion, redemption of the debentures in terms of the issue to the debenture holders, options available, and debt equity ratio and debt service coverage ratio, if applicable. 2. Details of charge created, in case of secured debentures. A. Nature of charge created and examination of title. B. Rank of charge created, viz. First, second, pari passu, residual, etc. C. Minimum security cover required. D. Complete details of the assets on which charge is created, such as description, nature, title, location, value, basis of valuation, etc. Methods and mode of preservation of assets charged as security for the debentures. F. Other particulars of the charge, for example, time period of charge, rate of interest, name of the charge holder. G. Provision for subsequent valuation. H. Procedure for allowing inspection of charged assets and book of accounts by debenture trustee or any person or person authorized by it. I. Charging of future assets. J. Time limit within which the future security for the issue of debentures shall be created. K. Circumstances specifying when the security may be disposed of or leased out with the approval of trustees. L. Enforceability of securities, events under which security becomes enforceable. M. Obligation of company not to create further charge or encumbrance of the trust property without prior approval of the trustee. 3. Particulars of the appointment of debenture trustees. A. The conditions and procedure for the appointment of the debenture trustee. B. Procedure for resignation by trustee, including appointment of new trustees. C. Provision that the debenture trustee shall not relinquish his office until another debenture trustee has been appointed. D. Procedure to remove debenture trustee by debenture holders, providing for removal on a resolution passed by the holders of not less than 3/4 in value of debentures. E. Fees or commission or other legal traveling and other expenses payable to the trustees for their services. F. Rights of the trustee, including the right to inspect the registers of the company and to take copies and extract thereof, and the right to appoint a nominee director. G. Duties of the trustee. 4. Events of defaults. A. Events under which the security becomes enforceable, which shall include the following events. I. When the company makes 2 consecutive defaults in the payment of any interest which ought to have been paid in accordance with the terms of the issue. 2. When the company without the consent of debenture holders ceases to carry on its business or gives notice of its intention to do so. 3. When an order has been made by the tribunal or a special resolution has been passed by the members of the company for winding up of the company. 4. When any breach of the terms of the prospectus inviting the subscriptions of debentures or of the covenants of this deed is committed. V. When the company creates or attempts to create any charge on the mortgaged premises or any part thereof without the prior approval of the trustees, debenture holders. V. When in the opinion of the trustees the security of debenture holders is in jeopardy. B. Steps which shall be taken by the debenture trustee in the event of defaults, circumstances specifying when the security may be disposed of or leased out with the approval of trustees. D. A covenant that the company may hold and enjoy all the mortgaged premises and carry on therein and there with the business until the security constituted becomes enforceable. 5. Obligations of company. This section shall state the company's duty with respect to maintaining a register of debenture holders, including addresses of the debenture holders, record of subsequent transfers and changes of ownership. B. Keeping proper books of accounts open for inspection by debenture trustee. C. Permitting the debenture trustee to enter the debenture holder's premises and inspect the state and condition of charged assets. D. Furnishing information required by the debenture trustee for the effective discharge of its duties and obligations, including copies of reports, balance sheets, profit and loss account, etc. E. Keeping charged property, security adequately insured and in proper condition. F. Paying all taxes, cesses, insurance premium with respect to charged property, security, on time. G. Not declaring any dividend to the shareholders in any year until the company has paid or made satisfactory provision for the payment of the installments of principal and interest due on the debentures. H. Creating the debenture redemption reserve. I. Converting the debentures into equity in accordance with the terms of the issue, if applicable. J. Informing the debenture trustee about any change in nature and conduct of business by the company before such change. K. Informing the debenture trustee of any significant changes in the composition of its board of directors. L. Informing the debenture trustee of any amalgamation, merger or reconstruction scheme proposed by the company. M. Keeping the debenture trustee informed of all orders, directions, notices, of court, tribunal affecting or likely to affect the charged assets. N. Not creating further charge or encumbrance over the trust property without the approval of the trustee. O. Obligation of the company to forward periodical reports to debenture trustees containing the following particulars. I. Updated list of the names and addresses of the debenture holders. 2. Details of interest due but unpaid and reasons thereof. 3. The number and nature of grievances received from debenture holders and, A. Resolved by the company, B. Unresolved by the company and the reasons for the same. 4. A statement that the assets of the company which are available by way of security are sufficient to discharge the claims of the debenture holders as and when they become due. P. Complying with all directions, guidelines issued by a regulatory authority, with regard to the debenture issue. Q. Submitting such information, as required by the debenture trustee. 6. Miscellaneous. A. The conditions under which the provisions of the trust deed or the terms and conditions of the debentures may be modified. B. The mode of service of notices and other documents on the company, the trustee and the holders of the debentures. C. The company to be responsible for paying any stamp duty on the trust deed or the debentures, if applicable. D. Provisions regarding meetings of the debenture holders. E. Provisions for redressal of grievances of debenture holders. Issue and listing of non-convertible debt instruments. Securities and Exchange Board of India, Issue and listing of debt securities, Regulations, 2008, shall apply to a public issue of debt securities where debt securities means the non-convertible debt securities which create or acknowledge indebtedness, and include debenture, bonds and such other securities of a body corporate or any statutory body constituted by virtue of the legislation, whether constituting a charge on the assets of the body corporate or not, but excludes bonds issued by government or such other bodies as may be specified by the board, security receipts and securitized debt instruments, and, b. listing of debt securities issued through public issue or on private placement basis on a recognized stock exchange. The company can make any public issue of debt securities only if, as on the date of filing of draft offer document and final offer document, the issuer or the person in control of the issuer, or its promoter, has not been restrained or prohibited or debarred by the board from accessing the securities market or dealing in securities in such direction or order as in force. Procedure for public issues of non-convertible debt instruments under SEBI, Issue and Listing of Debt Securities, Regulations, 2008 I. Call a board meeting after giving notice to all the directors of the company to decide following about the issue of debentures. Whether the debenture is non-convertible, or fully or partly convertible. Credit rating. Appointment of trustee. Appointment of lead managers and other intermediaries. 2. Make an application to one or more recognized stock exchanges for listing of such securities therein. If the application is made to more than one recognized stock exchanges, the issuer shall choose one of them as the designated stock exchange. If the application is made to any of the stock exchanges having nationwide trading terminals, the issuer shall choose one of them as the designated stock exchange. 3. Obtain in principle approval for listing of its debt securities on the recognized stock exchanges where the application for listing has been made. 4. Obtain credit rating from at least one credit rating agency registered with the board and disclose it in the offer document. V. Enter into an arrangement with the depository registered with the board for dematerialization of the debt securities that are proposed to be issued to the public, in accordance with the Depositories Act, 1996 and regulations made thereunder. 5. Appoint one or more merchant bankers registered with the board, at least one of whom shall be a lead merchant banker. 7. Appoint one or more debenture trustees in accordance with the provisions of Section 71 of the Companies Act, 2013 and Securities and Exchange Board of India, Debenture Trustees, Regulations, 1993. 8. No debt securities will be issued for providing loan to or acquisition of shares of any person who is part of the same group or who is under the same management. 9. Prepare an offer document containing following material disclosures which are necessary for the subscribers of the debt securities to take an informed investment decision. The disclosures specified in Section 26 of the Companies Act, 2013. Disclosure specified in Schedule I of SEBI Issue and Listing of Debt Securities, Regulations, 2008. Additional disclosures as may be specified by the Board. X. File the draft offer document with the designated stock exchange through the lead merchant banker and post the same on the website of the designated stock exchange for seeking public comments for a period of 7 working days from the date of filing the draft offer document with such exchange. Also display the draft offer document on the website of the issuer, merchant bankers and the stock exchanges where the debt securities are proposed to be listed. 11. Following shall be ensured by the lead merchant banker. The draft offer document clearly specifies the names and contact particulars of the compliance officer of the lead merchant banker and the issuer, including the postal and email address, telephone and fax numbers. All comments received on the draft offer document are suitably addressed prior to the filing of the offer document with the Registrar of Companies. 12. Forward a copy of draft and final offer document to the board for its records. 13. Obtain a due diligence certificate as per Schedule 2 of these regulations from the lead merchant banker shall, prior to filing of the offer document with the Registrar of Companies. 14. Obtain a due diligence certificate as per Schedule 3 of these regulations from the debenture trustee prior to the opening of the public issue. 15. Both the draft and final offer documents shall be displayed on the websites of stock exchanges and shall be available for download in PDF/HTML formats. 16. File the offer document with the designated stock exchange, simultaneously with filing thereof with the Registrar of Companies, for dissemination on its website prior to the opening of the issue. Also make physical copy of the offer document to the person demanding it. 17. Make an advertisement in a national daily with wide circulation, on or before the issue opening date, and such advertisement shall, amongst other things, contain the disclosures as per Schedule 4. 18. Ensure that every application form issued by the issuer is accompanied by a copy of the abridged prospectus. 19. The company may propose to issue debt securities to the public through the online system of the designated stock exchange. 20. The issuer may determine the price of debt securities in consultation with the lead merchant banker, and the issue may be at fixed price, or the price may be determined through book building process in accordance with the procedure as may be specified by the board. 21. The minimum subscription for public issue of debt securities shall be 75% of the base issue size. 22. A public issue of debt securities may be underwritten by an underwriter registered with the board, and in such a case adequate disclosures regarding underwriting arrangements shall be disclosed in the offer document. 23. The offer document shall not omit disclosure of any material fact which may make the statements made therein, in light of the circumstances under which they are made, misleading. The offer document or abridged prospectus or any advertisement issued by an issuer in connection with a public issue of debt securities shall not contain any false or misleading statement. 24. A trust deed for securing the issue of debt securities shall be executed by the issuer in favor of the debenture trustee within 3 months of the closure of the issue, containing such clauses as may be prescribed under Section 71 of the Companies Act, 2013, and those mentioned in Schedule 4 of the Securities and Exchange Board of India, Debenture Trustees, Regulations, 1993. 25. Create debenture redemption reserve in accordance with the provisions of the Companies Act, 2013. 26. Disclose the proposal to create a charge or security, if any, in respect of secured debt securities in the offer document along with its implications. 27. Keep all the issue proceeds in an escrow account until the documents for creation of security as stated in the offer document are executed. Procedure for redemption and rollover of non-convertible debt securities under SEBI, Issue and Listing of Debt Securities, Regulations, 2008 I. The issuer shall redeem the debt securities in terms of the offer document. 2. Where the issuer desires to roll over the debt securities issued by it, it shall do so only upon passing of a special resolution of holders of such securities and give 21 days notice of the proposed rollover to them. 3. The notice shall contain disclosures with regard to credit rating and rationale for rollover. 4. The issuer shall, prior to sending the notice to holders of debt securities, file a copy of the notice and proposed resolution with the stock exchanges where such securities are listed, for dissemination of the same to public on its website. V. The debt securities issued can be rolled over subject to the following conditions. The rollover is approved by a special resolution passed by the holders of debt securities through postal ballot having the consent of not less than 75% of the holders by value of such debt securities. At least one rating is obtained from a credit rating agency within a period of 6 months prior to the due date of redemption and is disclosed in the notice referred to in sub-regulation. 2. Fresh trust deed shall be executed at the time of such rollover, or the existing trust deed may be continued if the trust deed provides for such continuation. Adequate security shall be created or maintained in respect of such debt securities to be rolled over. 5. Redeem the debt securities of all the debt securities holders, who have not given their positive consent to the rollover. Procedure for listing of non-convertible debt securities under SEBI, Issue and Listing of Debt Securities, Regulations, 2008 I. Make an application for listing to one or more recognized stock exchanges in terms of Section 40 of the Companies Act, 2013. 2. Comply with conditions of listing of such debt securities as specified in the listing regulation with respect to debt securities. 3. Where the issuer has disclosed the intention to seek listing of debt securities issued on private placement basis, the issuer shall forward the listing application along with the disclosures specified in Schedule I-4, for listing of debt securities issued on private placement basis on a recognized stock exchange. The following conditions have to be fulfilled. The issuer has issued such debt securities in compliance with the provisions of the Companies Act, 2013, rules prescribed thereunder and other applicable laws. B. Credit rating has been obtained in respect of such debt securities from at least one credit rating agency registered with the board. C. The debt securities proposed to be listed are in dematerialized form. D. The disclosures as specified in Schedule I of the SEBI, Issue and Listing of Debt Securities, Regulations, 2008 have been made in the websites of stock exchanges where such securities are proposed to be listed and shall be available for download in PDF/HTML formats. E. Where the application is made to more than one recognized stock exchange, the issuer shall choose one of them as the designated stock exchange. F. Comply with conditions of listing of such debt securities as specified in the listing regulation with respect to debt securities. G. The designated stock exchange shall collect a regulatory fee as specified in Schedule V from the issuer at the time of listing of debt securities issued on private placement basis. Consolidation and reissuance, Regulation 20A. An issuer may carry out consolidation and reissuance of its debt securities, subject to the fulfillment of the following conditions. A. There is such an enabling provision in its articles under which it has been incorporated. B. The issue is through private placement. C. The issuer has obtained fresh credit rating for each reissuance from at least one credit rating agency registered with the board and is disclosed. D. Such ratings shall be revalidated on a periodic basis and the change, if any, shall be disclosed. E. Appropriate disclosures are made with